Hello everyone, welcome to my channel. I will be discussing some of the salient points of the Criminal Law Book 1 of the Revised Penal Code. What is criminal law? Criminal law is the branch or division of public law which defines crimes, treats of their nature, and provides for their punishment. There are limitations as well on the power of the lawmaking body to enact the penal legislation. First, no ex post facto law or Bill of Attainder shall be enacted, according to the Article 3 Bill of Rights of the Philippine Constitution, that is Section 22. And next is no person shall be held to answer for a criminal offense without due process of law. And that is being stipulated in Article 3, Section 15 as well of the Philippine Constitution. And next, they must not impose cruel and unusual punishment or excessive fines. Okay, there are characteristics of criminal law. First, generality. Second, territoriality. And the third one is the prospectivity. Okay, so what is generality? So generality, our criminal law is binding on all persons who live or sojourn in the Philippine territory. There are exceptions to this as to the general application of our criminal law. They are treaties or treaty stipulations, the law of preferential applications, and the principles of public international law. To say, for example, in the law of preferential application, as one of the exceptions, they are the sovereigns, and others chief of states, ambassadors, ministers plenipotentiary, minister resident, and charges the affairs. And you have to take note that consuls, the vice consul, and other foreign commercial representatives, they cannot claim the privileges and immunities that is accorded to ambassador and ministers. Okay, the consul is not included again, So who is this consuls? It is a government official who lives or resides in another country to look for the welfare of his countrymen. As to the generality, here is an example, no? So, in a case where the accused contended that being an American citizen, he cannot be persecuted for, much less convicted of, the crime of illegal possession of firearms, because it's a constitutional rights of the citizens of the USA to keep and bear arms without any need of applying and securing a government license. Therefore, the Court of Appeals held that the Philippines is a sovereign state with the obligation and the right of every government to uphold its laws and maintain order within its domain, and with the general jurisdiction to punish persons for offenses committed within its territory, regardless of the nationality of the offender. Okay, next, territoriality, another characteristics of our criminal law. So, our criminal laws undertake to punish crimes committed within Philippine territory. So, the principle of territoriality means that, as a rule, penal laws of the Philippines are enforceable only within its territory. Okay, so there are exceptions. In Article 2 of the Revised Penal Code, the binding even on crimes committed outside the Philippines. They are the following: offense committed while on Philippine ship or airship. Again, when can we say that that is a Philippine ship or an airship? You have to take note that it is belong to the Philippines if it is registered to our Bureau of Customs, no? Hindi magmamatter yung citizenship of the owner of the said vessel or the ship, but the registration of the vessel. Another, forging or counterfeiting any coin or currency note of the Philippines or obligations and the securities issued by the government. Introduction into the country of the above-mentioned obligation and securities, and while being public officers and employees an offense committed in the exercise of their functions, and of course, crimes against national security in the law of the nation that is defined in the Title 1 of the Book 2. Okay, let's talk about these mga rules, no? Okay, as to the Philippine vessel or ship, again, the Philippine law shall apply to offenses committed in vessels that is registered with the Philippine Bureau of Customs, no? It is the registration, not the citizenship of the owner, which matters. Okay, foreign vessel. We have here French rule. Okay, general ruling of the French rule. Crimes committed aboard a foreign vessel within the territorial waters of a country are not triable in the courts of such country. So, meaning to say, the host country has no jurisdiction. Walang jurisdiction ang host country over the crime committed within the vessel. So, sino ang may jurisdiction? Saan magmatter? Anong titingnan? Ang flag, no? Pero meron pa ring exceptions. If it affects the peace, no? Unless. If affects the peace, the public safety of the host country, then they have the jurisdiction over that case. Again, exception commission affects the peace and security of the territory or the safety of the state is endangered. Okay, next, we have English rule. So, as the general rule of this, crimes committed aboard a foreign vessel within the territorial waters of a country are triable in the courts of such country. So, sino naman dito yung may jurisdiction? It is the host country. Sila ang mayroong jurisdiction over the crime committed within the vessel. Okay, example, the Philippine merchant vessel entered in China. Ano ba itong merchant vessel? No? Karaniwang barko, no? Okay, that is used for transportation. Okay, again, Philippine merchant vessel entered in China. There is a crime occurred inside the Philippine merchant vessel. Sinong may jurisdiction? So, the China has jurisdiction over this case, no? Since they are the host country. The general ruling of the English rule na yung mayroong jurisdiction talaga, yung host country man, di ba? Pero meron pa ring exception ito, no? You have to be very mindful with the exception. Crimes involve internal management of the vessel. Ano ba itong internal management? Sinong involved? The crew or employee, no? So, example, both crew, they suffered physical injury as a result of their duel. So, this is being held that the Philippines has the jurisdiction over this case. Okay, next. We have here rule on warship as well, no? So, ito yung formula niya, no? Crime equals jurisdiction equals origin, no? Okay, so for example, our Philippine warship entered in China. There is a crime occurred inside the Philippine warship. Sinong may jurisdiction? Pilipinas pa rin. Bakit? Kasi yung warship that is considered as an extension of our territory. Okay, next characteristic, we have prospectivity. The law shall not have any retroactive effect talaga, no? Lex prospecet, non respecet, ika nga, no? The law looks forward, not backward. Okay, in Article 21 of the Revised Penal Code, no felony shall be punishable by any penalty prescribed by law prior to its commission. But still, there is an exception, no? In Article 22 of the Revised Penal Code. The penal law shall have a retroactive effect insofar as they favor to the accused, provided na yung akusado na yan not a habitual delinquent. Okay? Ganda naman, no? Okay, so let's talk about the exception to the rule of prospectivity, no? So here are the example as to its retroactivity. So there are some illustrations here, no? Okay, let us assume that X committed an offense punishable by reclusion perpetua at the time it was committed. During the trial, a law was passed. Meron na namang bago, no? Increasing the penalty of such offense to death. Instead na reclusion perpetua, naging death. Ano kayang mangyayari nito? Saan ba pabor ang akusado dito, no? In case he is convicted after trial, the court cannot impose the penalty of death, no? Because the law is not favorable to him. So, saan ba yung favorable sa akusado? Death or reclusion perpetua? Ano ba yung mas mabigat? Mabigat yung death. So, hindi yan, no? So, ito dito tayo sa reclusion perpetua, no? Hindi itong death kasi it increase the penalty at hindi yan magiging pabor sa akusado. Kaya ito na, i-reverse natin. But if we were to reverse this, no? This illustration, where at the time of the commission of the offense, the imposable penalty was death. Death naman yung nauna, no? And during the trial, it was reduced to only reclusion perpetua. Ano mangyayari kaya, no? Then, it can be retroactive because the law is favorable to the accused. So, ganyan ang labanan. Merong merong limitation, no? Hindi ito all the time, no? Ang swerte-swerte naman ng accused na yan, no? But again, even if it is penal in nature and favorable to the accused, still there is another condition para mabigyan ito ng retroactivity. That is, he must not be a habitual delinquent or a recidivist. Later on, we will discuss this, no? Okay, if he is, then the law is not retroactive. Dapat lalaga ng hindi ang akusado na yan, hindi yan habitual delinquent. Yung for repetition, dapat wala siya, no? In sum, for a penal law to have retroactive effect, it must be favorable to the accused and the latter must not be a habitual delinquent or a recidivist, no? Yan yung pinaka-importante, no? The elements must concur. Okay, so again, I included some of this as well, no? Kasi yung iba nakakaligtaan natin. So minor lang naman. Felonies. Ano bang kaiba-ibahan nito? Felonies, an act or omission punishable by the revised penal code. So the crime, an act or omission punishable by any law. Yung ano ba yung kaibahan ng act at saka omission? We say act, overt, no? Physical deed or external act, katulad ng yung sa Bisaya, imuhang subagon, kulatahon, sagpaon, no? That is an act, no? An external, that is an example of an external act. So it is differ, no? Contrary to that, the omission, that is something, a failure to perform a duty that is required by law. Okay, there are classification of felonies according to the means by which they are committed. So we have here intentional felonies. So by means of deceit or dolo. Okay, there are requisites of intentional felonies: freedom, intelligence, and intent. Okay, so again, have freedom and intelligence, no? Without this power necessary to determine the morality of human acts, no crime can exist, no? Thus, the imbecile, insane, and as well as the minor over 9 but less than 15 years old and acting without discernment have no criminal liability because they act without intelligence. Intent, no? Intent to kill is difficult to prove, no? It being a mental act, but it can be deducted from the external acts that is being performed by a person. Okay, next, no? Let's talk about mistake of fact. Ano ba to? Yung ignorantial lihis ng excusance or ignorance of the law, excuses no one, no? Ignorance or mistake of fact, it relieves the accused from criminal liability. So, iba itong sa ignorantial lihis. Iba it sa mistake of fact, no? Mistake of fact, that is a misapprehension of fact on the part of the person who caused injury to another. So, therefore, he is not, however, criminally liable. Again, in mistake of fact, the offender is not criminally liable because he did not act with criminal intent. You must remember that an act is not a crime if the mind is not criminal, no? In mistake of fact, there is an honest mistake of fact here. It destroys the presumption of criminal intent which arises upon the commission of a felonious act. Okay, say for example, no, in mistake of fact, so I included here some of the mga stipulations, no, mga illustrations that is being held in the revised penal code. So in mistake of fact, the act done by the accused would have been constituted, no, justifying circumstances. Ito, katulad nitong US versus Atchong. So ito yung facts. Atchong was a cook in Fit McKinley. He was afraid of bad elements. So one evening, before going to bed, he locked himself in his room by placing a chair against the door. After having gone to bed, he was awakened by someone trying to open the door. He called out twice, "Who is there?" but received no answer. Fearing that the intruder was a robber, he leapt from his bed and called out again, "If you enter the room, I will kill you." But at that precise moment, he was struck by the chair that had been placed against the door, and believing that he was being attacked, he seized a kitchen knife and struck and fatally wounded the intruder, who turned out the eye to be his roommate. So it is being held that Atchong must be acquitted because of mistake of fact. Ito yung sinasabi kong honest misapprehension of fact, no? Okay, so ito na, merong ibang scenario, no? Tingnan natin tong People versus Juanes. So here is the facts, no? Chief of Police Juanes and his co-accused Corporal Galanta were under instruction to arrest one, itong si Balagtas, a notorious criminal and escaped convict, and if overpowered, to get him dead or alive. Proceeding to the suspected house, they went into a room, and on seeing a man sleeping with his back towards the door, simultaneously fired at him with their revolvers, without first making any reasonable inquiry as to his identity. Now the victim turned out to be an innocent man, that is Texan, and not the wanted criminal. So ano mangyayari? Both accused are guilty of murder. No, even if it were true that the victim was the notorious criminal, the accused would not be justified in killing him while the latter was sleeping. In apprehending even the most notorious criminal, no, the law does not permit the captor to kill him. It is only when the fugitive from justice is determined to fight the officers of the law who are trying to capture him that killing him would be justified. Alright, so the mistake, in order for it to be justifying, no, the mistake must be without fault or carelessness on the part of the accused. No, i-distinguish natin itong Atchong case at saka yung Juanes, no? In the Atchong case, there is an innocent mistake of fact without any fault or carelessness on the part of the accused, because having no time or opportunity to make any further inquiry and being pressed by the circumstances to act immediately. The accused had no alternative but to take the facts as they then appeared to him. Wala na siyang enough time pa, no? And such facts justified his act of killing the deceased. Now, in the Juanes case, iba naman to. The accused found no circumstances whatever which would press them to immediate action, no? The person in the room being then asleep. The accused had ample time and opportunity to ascertain his identity without hazard to themselves, no, and could even effect a bloodless arrest if any reasonable effort to that end had been made, as the victim was unarmed. Now, this indeed is the only legitimate course of action for the accused to follow, even if the victim was really Balagtas, as they were instructed not to kill Balagtas at sight, but to arrest and to get him dead or alive. Only if resistance or aggression is offered by him. No, hence, the accused in the Juanes case were at fault when they shot the victim in the violations of the instructions given to them. They were also careless in not verifying first the identity of the victim. That is why this is not a justifying circumstances, but only in the first case. Okay, so I hope you get the difference, no? Okay, now let's talk about the difference, no, between intentional and culpable felonies. Okay, again, in intentional felonies, the act or omission of the offender is malicious. The act is performed with deliberate intent. Big sabihin with malice. The offender, in performing the act or incurring the omission, has the intention to cause an injury to another. Now, the culpable felonies, this is by means of fault or culpa, no? So, requisites here is freedom, intelligence, and negligence, no? Negligence and imprudence. So, we say negligence, lack of foresight, imprudence, lack of skill. Okay? So, lack of skill, lack of foresight, no? Itong negligence, no? Deficiency of perception, no? If a person fails to pay proper attention and to use due diligence in foreseeing the injury or damage impending to be caused, no, there is negligence, no? Negligence usually involves lack of foresight. Imprudence, or the lack of skill, or indicates deficiency of action. If a person fails to take the necessary precaution to avoid the injury to person or damage to property, there is imprudence. Okay, let us distinguish the mala in se and mala prohibita. Okay, mala in se or malum in se in its singular form, first, no, it is a Latin phrase which literally translates to wrong in or of itself, no? These are acts or omissions in contrast with mala prohibita. So, kabaliktaran ito sa mala prohibita, which do not need special criminal statutes to criminalize those acts or omission simply by violating such special laws. Now, in mala in se, the acts or omission itself are inherently wrongful and immoral. These are acts which our society, our traditions, and our parents consider as naturally and organically evil. Thus, they are acts and omission which are wrong because they violate the moral, natural, or public principles of our society. So, in the mala prohibita, it does not require motive. No, at the rest of being repetitive, those are acts are not evil or wrong per se. Per se means in itself, no? They are only wrong because those acts or omission are prohibited and punishable by law. Diba? There is no crime and there is no law punishing it. So, in this type of crime, the motive or intent is not that much important since it is sufficient that a special law has been breached. For instance, no, if a person was arrested for violating an ordinance which implements liquor ban, it is not required to know what is his intention or motive for disregarding the liquor ban, no? It is sufficient that he has transgressed the law. Ano ba itong transgressed the law? Nilabag niya ang batas. Meron siyang nalabag na batas, no, which prohibited, no? Or ang paglabag sa batas. Regardless of his motive or intent, no, the possession of liquor. Okay, in offenses mala prohibita, the forbidden acts might not be inherently immoral, yet still they are penalized because the law says they are unlawful. Okay, so let's talk about the moral trait of offender, no? In mala in se, it is considered. In mala prohibita, not considered. So as to the good faith as a defense, in mala in se, valid defense siya, no? Unless the crime is the result of culpa. In mala prohibita, that is not a defense, no? Intent, that is not necessary. Sufficient that the offender has the intent to perpetrate the act prohibited by the special law. As to the degree of accomplishment of the crime, in mala in se, it is taken into account. In mala prohibita, taken into account only when consummated. Okay, so, yun na naman na consummated, all the elements are present. And then, as to mitigating and aggravating circumstances, in mala ense, taken into account in imposing penalty. In mala prohibita, generally not taken into account. Kaya, so the degree of participation in mala ense, when there is more than one offender, it is taken into consideration. In mala prohibita, generally they are not. As to the laws violated, mala ense, general rule, it is the revised penal code. And the mala prohibita, ano ba itong inaano niya? General, as a general, ito lang yung special penal laws. Okay, let's talk approximate cause. Is it cause which in natural and continuous sequence, unbroken by any efficient intervening cause, produces the injury and without which the result would not occurred. Kung hindi dahil sa kanya, wala sa nang ganong nangyari, no? So, facts. Accused Ramon Loses gave a fist blow on the stomach of Feliciana. Again na, sino yung nagbigay ng fist blow? Si Ramon. Sinong binigyan niya? Si Feliciana. Okay, causing her to fall unconscious. She never regained consciousness. Ito na, hindi na nagising. And a few minutes thereafter, she died. No? After niyang sinuntok, hindi na naka-regain ang kanyang consciousness. After a few minutes, namatay. Now, in the autopsy report, it was found that the probable cause of death was cardiac failure. Hindi yung pagsuntok niya, no? Cardiac failure pala rin reason. Now, the accused, he contended that the fist blow was not the proximate cause of Feliciana's death. Hindi talaga ito yung cause. Now, what is being held here? Whether Feliciana died as a direct effect of the fist blow or as an outcome of the fall that followed the blow, or as a consequence of the blow and the fall that caused her to lose consciousness, or of heart failure due to shock caused by the blow and her fall to the ground, the result would be the same, no? That the blow was the primary and the proximate cause of her death. Siya pa rin yung pinaka-cause, no? Always remember that he who is the cause of the cause is the cause of the evil cause, no? El que es causa del mal causado rather. El que es causa de la causa is causa del mal causado. Okay, so that's how it goes, no? And now let's talk about the impossible crime. Okay, here are the requisites of the impossible crime. Now, impossible crime, is it really a crime or not? And is it being punished? Okay, we'll know this one, no? So, requisites. That the act performed would be an offense against persons or property. Again na, against persons or property. That the act was done with evil intent. That the act performed should not constitute a violation of another provision of the revised penal code. Okay? Again, impossible crime occurs when there is, first, inherent impossibility. Second, inadequate means to consummate the crime. Next, ineffectual means to consummate the crime. Okay? Inherent impossibility, imposible, no? Imposible niyang mapatay, ipatay na yon. And then, inadequate means hindi enough, no? Ineffectual, hindi siya umepekto, hindi siya ganun ka, that is not. Okay. So, first, felonies against property are, let's say for example, robbery, brigandage, theft, usurpation, culpable insolvency, swindling and other deceits, chattel mortgage, arson and other crimes involving destruction, malicious mischief, no? Okay, so let's talk about the first, no, which is against person. Okay, here is an example. Okay, A fired at B, who was lying on bed, not knowing that B was dead hours before. So, ito, patay na pala itong si B, no? In crimes against person, as would have been in this case, it is necessary that the victim could be injured or killed, A dead person cannot be injured or killed. Had B been alive when he was shot, and as a consequence he died, the crime committed by A would have been murder. Pero patay na eh. So, hindi na ito murder. A crimes against person, no? Okay, so ito yung ibig sabihin na there is physical and legal impossibility, no, in this example. Kasi, paano niya mapapatay? Patay na yon, no? Okay, next, sa property naman tayo. Okay, A, with intent to gain, took a watch from the pocket of B. When A had the watch in his possession, he found out that it was the watch he had lost a week before. Ito, kinuha niya yung watch. Kinuha ni A yung watch ni B, no? Pag nasa kanya na, uy, sa akin pala to, ito pala yung nawala ko nung isang linggo, no? So, theft ba to? Diba? Yung isa sa mga requisites, elements ng theft, dapat the property is belonging to another person. No, ito, kaninong property ba to? Di ba sa kanya din? Hindi to other person, hindi siya pasok. In other words, the watch belonged to A, no? So, this is this an impossible crime? Okay, it is believed that it may be an impossible crime, no? The act performed would have been theft had the watch been the property of B, is what I've said a while ago. But there is a legal impossibility of accomplishing it because in theft, the personal property taken must belong to another. Okay, next. How about the employment? The number 2, inadequate. That is not sufficient, not enough, no? Yung ginamit niya, okay? So, for example, A, determined to poison B. He uses a small quantity of arsenic by mixing it with the food given to B, believing that the quantity employed by him is sufficient. Maraming namamatay sa maling akala. Akala niya lang enough na, adequate na yun, hindi pala, no? But since, in fact, it is not sufficient. Ano nangyari kay B? Patay o hindi? Of course, hindi, no? Kasi konti lang eh. Dinamihan niya sana, no? The means employed or that small quantity of poison is inadequate to kill a person. No? So, where the means employed is adequate, okay, but where the means employed is adequate and the result expected is not produced, it is not an impossible crime but a frustrated felony. Thus, if the quantity of poison used is sufficient to kill an ordinary person, but the intended victim has developed strong resistance to poison because he's been working in the mine, the crime committed is frustrated murder. Ito sana yung mangyayari. Walang nangyari. Kasi nga, hindi enough. So, impossible crime. Okay, next. Ineffectual. Ito, hindi naman umepekto. A tried to kill B by putting in his soup a substance which he thought was arsenic. Akala na naman niya, arsenic, no? Poisonous naman to. Okay, when in fact, it was sugar. So, akala niya, namatay ba? Hindi, sugar lang yun, no? So, that is why ineffectual means. Okay, so, impossible crime. Now, why do we penalize? Bakit i-penalize natin itong commission ng impossible crime? Because a person who commits an impossible crime is a potential criminal. That's the very reason. Now, is impossible crime really a crime? The answer is no. An impossible crime is not really a crime. Objectively, the offender has not committed a felony, no? But subjectively, he is a criminal. Because meron nga tayong tinatawag na criminal tendency. It is being penalized because we consider him as a danger to our society. Ano ba itong penalty ng impossible crime? Article 59, it could be arresto mayor or a fine from 200 to 500 pesos. Okay, we are now here in the stages of execution, no? Okay, we have consummated, frustrated, and attempted. Okay, in consummated felony, a felony is consummated when all the elements, ito yung pinaka-note nyo ha, all the elements are present, no? All the elements na kailangan for its execution and accomplishment are present. Well, the frustrated felony, frustrated when the offender performs all the act of execution which would produce the felony as a consequence but which nevertheless do not produce it. by reason of causes independent will of the perpetrator. While the attempted felony, when the offender commences the commission of a felony directly by overt acts and does not perform all the acts of execution, which should produce the felony by reason of some cause or accident other than his own spontaneous desistance. Again, in consummated, all elements are present, perform niya lahat. The frustrated, na-perform niya lahat, hindi na-produce. Itong attempted, hindi niya na-perform lahat, no? Lahat ng kailangang i-execute. So, hindi rin produce. Okay. So, we are now in the Article 7, no? When light felonies are punishable. Light felonies are punishable only when they have been consummated. Of course, with the exception of those committed against persons or property. Okay, light felonies are those mga infractions of law for the commission of which a penalty of arresto minor or a fine exceeding 200 pesos or both is provided. Okay, the light felonies punishable by the revised penal code, they are slight physical injuries, theft, alteration of boundary marks, malicious mischief, intriguing against honor. Okay, the penalty for the above-mentioned crimes is arresto minor, or imprisonment from 1 day to 30 days, or a fine at exceeding 200 pesos. Okay, conspiracy. Conspiracy and proposal to commit felony. What is conspiracy? Requisites. 2 or more person come to an agreement. Meron silang kasunduan for the commission of felony. Anong ginawa nila? They decide to commit it. So, there is conspiracy. Okay, concept of conspiracy, no? As a crime in itself, example, conspiracy to commit rebellion, insurrection, treason, sedition, and kudita. And merely as a means to commit a crime, as a requisite for this, a prior and express agreement, no? Participants acted in concert or simultaneously, which is indicative of a meeting of the minds towards a common criminal objective. A note, no? Conspiracy to commit a felony is different from conspiracy as a matter of incurring criminal liability. The general rule, conspiracy to commit a felony is not punishable since it is merely a preparatory act. But there is an exception pa rin, no? When the law specifically provides for a penalty, like rebellion, insurrection, sedition, or kudita. Proposal to commit a felony. Requisites. A person has decided to commit a felony. Siya ba mismo yung gumawa? Hindi, no? He proposes its execution to some other person or person. So, ano ba yung kaibahan? As elements of conspiracy and proposal. In conspiracy, agreement to commit and commission. In proposal, again, the person decides to commit a crime and proposes the same to another, to the second person. As to the crimes, conspiracy to commit sedition, treason, rebellion, kudita, no? In proposal to commit treason, rebellion, kudita, no? But there is no proposal to commit sedition. Okay, let's talk about penalties. We have grave, less grave, and light. So, when I say grave felonies, those are mga afflictive penalties. 6 years and 1 day to reclusion perpetua. And the less grave felonies, those are correctional penalties. 1 month and 1 day to 6 years. And light felonies, arresto minor, no, 1 day to 30 days. Okay, now, dito na tayo. Dumating na talaga tayo sa jimaa. Okay, the justifying circumstances and circumstances which exempt from criminal liability. Ano ba ito? Article 11, justifying circumstances. Okay, where the act of a person is in accordance with the law. Okay, naaayon sa batas. such that said person is deemed not to have violated the law. So, general rule ha, in justifying circumstances, no criminal and civil liability incurred. Meron parang exception. There is civil liability with respect to paragraph 4 where the liability is borne by person benefited by the act. Okay, so part 1 of the self-defense, we're talking here in justifying pa. Okay, indispensable requirement, no? Itong self-defense, no? In self-defense, there must be actual physical assault or aggression or an immediate and imminent threat which must be offensive and positively strong, no? The defense must have been made during the existence of aggression, otherwise it is no longer justifying. While generally an agreement to fight, it does not constitute unlawful aggression, ha? Violation of the terms of the agreement to fight is considered as an exception. Okay, ano ba? So, say for example, in unlawful aggression, no? Okay, if it is actual, right? If it is actual, no? Meaning to say the danger is present, no? That is, it is actually in existence. So say for example, while A and B were cutting trees, they had that is iha, double ian. They had a heated argument. A suddenly slashed B with a bolo, whereby wounding B's right shoulder. A was about to deliver another blow, but B was able to retrieve his bolo and hacked A's stomach. Ano nangyari? A fell down and died a few moments later due to blood loss. So ito, isang self-defense din. That's what it means to being actual. Okay, next, imminent. The danger is on point of happening, no? For example, A and B were enemies and in numerous occasions, B threatened A that he will kill him when their paths will cross. So, papatayin talaga kita kapag mag-cross ng landas natin, no? One night, while A was coming back home, he saw B heading towards him. B had a gun and he pointed the gun at him. A, who was also armed with a gun, swiftly drew out his pistol and shot B. That is an imminent danger. Okay, you have to take note as well, no? Yung insulting words, no matter how objectionable, without physical force, it does not constitute unlawful aggression, no? A slap on the face, it's constitute unlawful aggression. No, yung retaliation na yan is not a self-defense, no? The unlawful aggression must come from the person who was attacked by the accused. No unlawful aggression when there is agreement to fight. Okay, next, reasonable necessity of the means employed to prevent or repel it. Say, for example, someone attacked you with a knife but you were carrying a firearm and you shot him. Justifiable ba yung ginawa mo? Commensurate ba yun? It is necessary because knife, okay lang yan, no? Because knife is considered as a dangerous weapon. So there is a reasonable necessity. Another, someone shouted at you and you slapped in the face, feeling angry, you shot him dead. There's no necessity. Overacting lang kayo ka, no? Okay, so this is not considered as a reasonable necessity, but unreasonable one. But the first one, it is, no? Okay, so you have to take note yung material commensurability, ha? Okay, next. As to the test of reasonableness, no? It depends on the weapon that is used by aggressor, the physical condition, the character, the size, and the circumstances of aggressor are needed to see this picture. Physical condition, the character, the size, and circumstances of person defending himself, the place and occasion of assault. Okay, rights included in self-defense. Defense of person, defense of rights protected by law, defense of property, only if there is also an actual and imminent danger on the person of the one defending, and defense of chastity. There are kinds of self-defense. Self-defense of chastity. Now, there must be an attempt to rape the victim. In defense of property, it must be coupled with an attack on the person of the owner or on one entrusted with the care of such property. In self-defense and libel, justified when the libel is aimed at a person's good name. Yung libel na written. Okay. Again, as the law, we have here, stand ground when in the right. The law does not require a person to retreat when his assailant is rapidly advancing upon him with a deadly weapon. You have to take note as well in justifying under RE 9262, which is the Anti-Violence Against Women and Their Children Act of 2004, victim survivors who are found by the courts to be suffering from battered woman syndrome do not incur any criminal or civil liability despite absence of the necessary elements. Kahit wala yun. Basta ito covered tong BWS, no? For the justifying circumstances of self-defense in the revised penal code. No, they do not concur criminal or civil liability. The battered woman syndrome, that is a scientifically defined pattern of psychological and behavioral symptoms found in women living in a battering relationships as a result of cumulative abuse, no? At least 2 battering episodes. Okay, as to self-defense, no? Defense of relatives, defense of strangers, no? Same, there is unlawful aggression, there is reasonable necessity. Yung ano lang, no? In case the provocation, defense of relatives, in case the provocation was given by the person attacked, the one making the defense, dapat they had no part therein, hindi siya kasali, no? Okay, in defense of stranger, the person defending be not induced by revenge or ano bang mga resentment or other evil motive. State of necessity or avoidance of greater evil or injury. So elements, the evil sought to be avoided actually exist. The injury feared to be greater than that done to avoid it. No other practical and less harmful means of preventing it. Okay, the necessity must not be due to the negligence or violations of any law by the actor. Next, paragraph 5, fulfillment of duty or lawful exercise of a right or office. Okay, accused acted in the performance of duty or in the lawful exercise of a right or office. The injury caused or offense committed by the necessary consequence of the due performance of the duty or the lawful exercise of such right or office. Okay, you have to take note now that the accused must prove that he was duly appointed to the position claimed, he was discharging at the time of the commission of the offense. It must also be shown that the offense committed was the necessary consequence of such fulfillment of duty or lawful exercise of a right or office. We are now in the exempting circumstances. Exempt from criminal liability. Okay, what is exempting circumstances? No? It is grounds for exemption from punishment because there is wanting in the agent of the crime any of the conditions which make the act voluntary or negligent. So, basis of this exempting circumstances, the exemption from punishment is based on the complete absence of intelligence, freedom of action, or intent, or on the absence of negligence on the part of the accused. Okay, so burden of proof, any of the circumstances is a matter of defense and must be proved by the defendant to the satisfaction of the court. Okay, what is the difference between justifying and exempting as to who or what is affected? So, in the justifying, it is the act. Yung exempting, yung actor. Okay, as to the nature of act, in justifying, act is considered legal. Yung exempting, the act is wrongful, but the actor is not liable. Okay, as to the existence, none, and then exempting, yes, but since voluntariness is absent, the actor is not liable. Okay, as to the liability, no criminal and civil liability yung justifying, there is civil liability lang itong Article 11. Okay, state of necessity. In exempting, there's no criminal liability, but there is civil liability except as to Article 12, no? Injury by mere accident and lawful cause. Okay, so here are some of the exempting circumstances. Paragraph 1, imbecility or insanity. So, general rule, the imbeciles or insane person, they are exempt from criminal liability. There is an exception here, no? The act was done during lucid interval. Meron talagang mga panahon na dumadating sa kanila na nasa tamang huwisyo sila, na sa tamang pag-iisip. Yun ang hindi exempted, no? Note, and of course, there is a circumstantial evidence for that, no? Defense must prove that the accused was insane at the time of the commission. Para ma-exempt siya, no? Dapat i-prove niya na yung panahon na ginawa niya yung krimen na yan, insane talaga, no? Because the presumption man kasi talaga sa ating law is that it always in favor of sanity. Okay. Another, paragraph 2, under 9 years of age. Requisite, offender is under 9 years of age at the time of the commission of the crime. There is absolute criminal irresponsibility in the case of a minor under 9 years of age. Okay, you have to take note under RA 9444 or the Juvenile Justice and Welfare Act of a minor 15 years and below is exempt from criminal liability. Okay, paragraph 3. Person over 9 and under 15 acting without discernment. Okay, note, no such minor must have acted without discernment to be exempt. Kasi pag with discernment, hindi na siya exempted, no? If with discernment, no, he is criminally liable. Ano ba itong discernment, no? This is a mental capacity, kapasidad ng isang tao na they can fully appreciate, alam na nila yung consequences of their unlawful act, no? Which is shown by the manner the crime was committed, the conduct of the offender after its commission. Again, let's get back, no, as to the presumption. The minor committed the crime without discernment. Good. Okay, under RA 9344, a minor over 15 but below 18 who acted without discernment is exempt from criminal liability. Itong discernment lang talaga yung mag-matter, no? Okay, paragraph 4. Accident without fault or intention of causing it. Okay, a person is performing a lawful act with due care, he causes injury to another, aksidente lang, no? Without fault or intention of causing it. Okay, exempting. Irresistible force. Ano ba tong irresistible force? The offender uses violence or physical force to compel, gipugos, no? Another person to commit a crime. So, as to the elements, the compulsion, yung ginawa niyang pamimilit is by means of physical force. And that physical force must be irresistible. Hindi mo talaga kayang pigilin yan, no? The physical force must come from a third person. Now, force must be irresistible, so as to reduce the individual to a mere instrument. Another exempting circumstances, uncontrollable fear. Ano ba itong uncontrollable fear? The offender employs intimidation or threat in compelling another to commit a crime. Okay, so as to the elements, the threat which causes the fear is of an evil greater than or at least equal to that which he is required to commit. It promises an evil of such gravity and imminence that an ordinary man would have succumbed to it. Yayakapin na lang talaga niya o ano ipapagawa mo sa kanya, no? Kasi he is being takot na takot kaya kahit gagawin niya. Exempting, no? Okay? Juries to be a valid defense should be based on real, imminent, or reasonable fear for one's life or limb. Ano nga yung juries? Use of violence or physical force. Okay, it should not be inspired by speculative, fanciful, or remote fear. No, a threat of future injury, that is not enough. Another exempting, insuperable cause. What is insuperable cause? some motive which has lawfully, morally, or physically prevented a person to do what the law commands, no? Elements. An act is required by law to be done. A person fails to perform such act. His failure to perform such act was due to some lawful or insuperable cause. Say, for example, a priest can be compelled to reveal what was confessed to him. Okay, next, mitigating circumstances. Okay, those which, if present in the commission of the crime, reduces the penalty of the crime. Pero hindi ibig sabihin na na-reduce, ma-erase na yung criminal liability niya or ma-change na yung nature ng crime. Kasi pag ma-change na, aggravating na yun, no? Okay, so, ano ba ito? Hindi ko na sinali yung lahat ng mga paragraph, ha? Okay, this is kuan lang. Okay, mitigating circumstances, paragraph 2, under 18 or over 70 years old. Okay, age of accused is determined by his age at the time of the commission of the crime, hindi yung trial day na ha, yung panahon kung kailan ang edad ng batang yan or ng taong yan nung panahon na ginawa niya yung krimen, hindi yung panahon ng trial. Okay, no intention, paragraph 3, no intention to commit so grave a wrong. No, it can be used only when the proven facts show that there is a notable and evident disproportions are needed to see this picture between the means employed to execute the criminal act and its consequences. Okay, you have to take note, no? In crimes against persons, if victim does not die, the absence of the intent to kill reduces the felony to mere physical injuries. No, it is not considered as mitigating. It is mitigating only when the victim dies. Okay, it is not applicable to felonies by negligence, no, because in felonies through negligence, the offender acts without intent. The intent in intentional felonies is replaced by negligence or imprudence. There is no intent on the part of the offender which may be considered as diminished. Paragraph 4, provocation or threat. Ano ba itong provocation? Any unjust or improper conduct or act of the offended party capable of exciting or inciting or irritating anyone. Sinagad mo talaga, no? Yung nangyari, tuloy ganyan, no? Provocation must be sufficient. It must originate from the offended party, must be immediate to the commission of the crime by the person who is provoked. Next, aggravating circumstances. Okay, those which, if attendant in the commission of the crime, serve to have the penalty imposed in its maximum period provided by law for the offense or those that change the nature of the crime. Okay, there are kinds of aggravating circumstances. First, generic, those which apply to all crimes. Specific, those which apply only to specific crimes. Qualifying, those that change the nature of the crime. Inherent, which of necessity accompany the commission of the crime, therefore not considered in increasing the penalty to be imposed. Special, those which arise under special conditions to increase the penalty of the offense and cannot be offset by mitigating circumstances. Paragraph 1, no, aggravating, that advantage be taken by the offender of his public possession, that the crime be committed in contempt of or with insult to public authorities, that the act be committed with insult or in disregard of the respect due to the offended party on account of his rank, age, or sex. As to the rank, the designation or title of distinction used to fix the relative position of the offended party in reference to others. Age, it may refer to old age or the tender age of the victim. As to the sex, it refers to the female sex, not to the male sex. Second, that it be committed in the dwelling of the offended party if the latter has not given provocation. What aggravates the commissions of the crime in one's dwelling ba, no? The abuse of confidence which the offended party reposed in the offender by opening the door to him, or the violation of the sanctity of the home by trespassing therein with violence or against the will of the owner. Again, the trespassing and violation of domicile that was discussed in the book 2 na, no, of the revised penal code. Okay, dwelling, no, that is not aggravating in the following cases, no, when both the offender and the offended party are occupants of the same house, and this is true even if offender is a servant in the house, no. There is exception here in case of adultery in the conjugal dwelling, the same is aggravating. However, if the paramour, yung kabit, no, also dwells on the conjugal dwelling, the applicable aggravating circumstances is abuse of confidence. Okay, there is requisites of abuse of confidence, no, that the offended party had trusted the offender, that the offender abused such trust by committing a crime against the offended party, that the abuse of confidence facilitated the commission of the crime. Paragraph 5, aggravating pa rin tayo, no? That the crime be committed in the palace of the chief executive or in his presence, or where public authorities are engaged in the discharge of their duties, or in a place dedicated to religious worship. Okay, actual performance of duties is not necessary when crime is committed in the palace or in the presence of the chief executive. Kaya ano naman itong kaibahan ng paragraph 5 at saka itong paragraph 2. The paragraph 5 where public authorities are engaged in the discharge of their duties. Okay, both itong dalawa, no, the public authorities are in the performance of their duties, no, and the place where public duty is performed. Itong paragraph 5 in their office, paragraph 2 outside, first offended party. In paragraph 5, may or may not be the public authority. Itong contempt or insult to public authority should not be the offended party. Okay, next, paragraph 7 of aggravating pa rin, no? That the crime be committed on the occasion of a conflagration, shipwreck, earthquake, epidemic, or other calamity or misfortune. Okay, paragraph 8, that the crime be committed with the aid of armed men or persons who ensure or afford impunity. In paragraph 9, the accused is a recidivist. Okay, ano ba itong recidivist? One who at the time of his trial for one crime shall have been previously convicted by final judgment of another crime. Of course, yung embrace niya same title. Kunyari, yung una, crimes against person. Pangalawa, crimes against person pa rin, no? For example, murder. Ano pa ba? Rape. Yung rape, crimes against person na yan ngayon. Hindi na yan crimes against chastity, no? Okay, so again, the requisites that the offender is on trial for an offense, that he was previously convicted by final judgment of another crime, that both the first and the second offenses are embraced in the same title of the code, that the offender is convicted of the new offense. Okay, ano bang ibig sabihin nitong at the time of his trial for one crime? It is employed in its general sense, no? Including the rendering of the judgment. No? It is meant to include everything that is done in the course of the trial, from arraignment until after sentence is announced by the judge in open court. What is controlling is the time of the trial, not at the time of the commission of the offense. Okay, general rule. Paano ba i-prove itong recidivism? It is necessary to allege the same in the information and to attach thereto certified copy of the sentences rendered against the accused. There is exemption, no? If the accused does not object, and when he admits in his confession and in the witness stand, in recidivism, it is sufficient that the succeeding offense be committed after the commission of the preceding offense, provided that at the time of his trial for the second offense, the accused had already been convicted of the first offense. Okay, if both offenses were committed in the same date, they shall be considered as only one. Hence, they cannot be separately counted in order to constitute recidivism. Also, judgments of convicted handed down on the same day shall be considered as only one conviction. No? Reason, because the code requires that to be considered as a separate conviction at the time of his trial for one crime, the accused shall have been previously convicted by final judgment of the other. No? Next, reiteration or habituality. The accused is on trial for an offense that he previously served sentence for another offense to which the law attaches ito ba equal ba or greater penalty ba, or for two or more crimes to which it attaches a lighter penalty than that for the new offense, and that he is convicted of the new offense. Ano bang kaibahan ng habituality at saka recidivism, no, in general sense? As to the first offense, itong habituality, it is necessary that the offender shall have served out his sentence for the first offense. Itong recidivism, enough na yung merong final judgment na narender sa kanyang first offense, no? Hindi necessary na nakaserve na talaga siya, no? As to the kind of offenses involved, in habituality, the previous and subsequent offenses must not be embraced in the same title of the code. Unlike recidivism requirement talaga same title. In the habituality, it is not. Okay? Okay, these are the four forms of repetition, ha? Including yung sinabi ko na kanina, yung recidivism, reiteration, habituality, yung dalawa pa, hindi pa, no? Yung multi-recidivism or habitual delinquency that was in Article 62, Paragraph 5, where a person within a period of 10 years from the date of his release or last conviction of the crimes of serious or less serious physical injuries, robbery, theft, estafa, or falsification is found guilty of the said crimes a third time or oftener na. That's habitual delinquency. And that's an extraordinary aggravating circumstance. Next, quasi-recidivism, Article 160, where a person commits felony before pa siya nagbegin to serve or while nag-serve siya sa kanyang sentence on a previous conviction for a felony. And this is a special aggravating circumstances, no? That's quasi-recidivism. Okay, next. Next aggravating, paragraph 14, ang daming aggravating, no? That craft, fraud, disguise is employed. Okay, yung requisite nyo, the offenders must have actually used craft, fraud, disguise to facilitate the commission of the crime. Okay, ano ba tong craft? Craft or astucia, no? It involved the use of intellectual trickery or cunning on the part of the accused, no? A chicanery resorted to by the accused to aid the execution of his criminal design. It is employed as a scheme in the execution of the crime. Okay, so say for example, no, in People versus San Pedro, dated January 22, 1980, no, where the accused pretended to hire the driver in order to get his vehicle. Now, it was held that there was craft directed to the theft of the vehicle. Yun talaga yung plano niya. Nakawin niya yung vehicle na yan, no? Separate from the means subsequently used to treacherously kill the defenseless driver. Pinatay pa talaga, no? Now, in People versus Masilang, there was also craft where after hitching a ride, the accused requested the driver to take them to a place to visit somebody when in fact they had already planned to kill the driver. Iba pala yung motibo niya. Mayroon napakakaning talaga. Gumamit talaga ng magaling na trickery. That is craft. Okay, fraud. Insidious words, or machination used to induce the victim to act in a manner which would enable the offender to carry out his design. Okay. Galing mong mambola. Okay, next. Disguise. Okay, resorting to any device to conceal identity. Itago ang iyong identity. The test of disguise is whether the device or contrivance resorted to by the offender was intended to or did make identification more difficult, such as the use of a mask or false hair or bird, the use of an assumed name in the publication of a libel. That constitutes a disguise. Ano ba yung kaibahan ng fraud at saka craft? Fraud, where there is a direct inducement by insidious word or machinations. Fraud is present. In craft, the act of the accused done in order not to arouse the suspicion of the victim, it constitutes craft. Kaya ngayon, kunyari nang-hit siya, kunyari binayaran niya yung driver, kunyari hinire niya, para hindi siya pagdudahan. Galing. Kaya nga may intellectual trickery. Okay, dito naman tayo sa ignominy and cruelty. Ano bang kaibahan nitong dalawa na to, That ignominy, it shocks the moral conscience of man, while cruelty, physical lang talaga to, Ignominy refers to the moral effect of a crime and it pertains to the moral order, whether or not the victim is dead or alive. That cruelty, it pertains to physical suffering of the victim. So the victim has to be alive. In plain language, ignominy, that is adding insult to injury. A clear example nitong ignominy is a married woman being raped before the eyes of her husband. Pinakita mo talaga sa asawa niya na paano mo ni-rape, That's adding insult. That's ignominy, ignominious act. Okay, so in a case where the crime committed is rape and the accused abused the victims from behind, the Supreme Court considered the crime as aggravated by ignominy, another ignominious act. Hence, raping a woman from behind is ignominious because that is not a usual intercourse. It is something which offends the moral of the offended woman. This is how animals do it. In a case of homicide, the victim, after having been killed by the offender, ito pa talaga yung ginawa niya, he shoved the body inside a canal. Again, aggravating kasi ignominy. After having been killed, the body was thrown into pile. Tinapon mo sa basurahan, aggravating pa rin kasi you are adding insult to the injury. Okay, the aggravating yan, the Supreme Court held that it added shame to the natural effects of the crime. Anything that added shame, to the natural effects of the crime, that's aggravating, and specifically, that's ignominious act. Okay, there is an illustration here. A and B are enemies. A, upon seeing B, pulled out a knife. Anong ginawa niya? He stabbed B 60 times. Will that fact be considered as an aggravating circumstances of cruelty na ba? No. There is cruelty only when there are evidence that the offender inflicted the stab wounds while enjoying or delighted to see the victim in pain. Okay, so for cruelty to exist as an aggravating circumstance, there must be evidence showing that the accused inflicted the alleged cruel wound slowly and gradually, and that he is delighted seeing the victim suffer in pain. Now, in the absence of evidence to this effect, there is no cruelty. 60 stab wounds do not ipso facto, or by that very fact, make them aggravating circumstances of cruelty. The crime is murder if 60 wounds were inflicted gradually. The absence of this evidence means the crime committed is only homicide. Yan yung tandaan, ha? Okay, cruelty is aggravating in rape where the offender tied the victim to a bed and burnt her face with a lighted cigarette while raping her laughing all the way. Nasisihan talaga siya mang ginagawa niya yun, no? That's cruelty. Aggravating pa rin. Next, alternative circumstances. The last but not the least circumstances. Okay, alternative circumstances are those which must be taken into consideration as aggravating or mitigating, according to the nature and the effects of the crime and the other conditions attending to its commission. They are the relationship, intoxication, the degree of instruction, and education of the offender. The alternative circumstance of relationship shall be taken into consideration when the offended party is the spouse, ascendant, descendant, legitimate, natural, or adopted brother or sister, or relative by affinity in the same degrees of the offender. Okay, the intoxication of the offender shall be taken into consideration as a mitigating circumstance when the offender has committed a felony in a state of intoxication. If the same is not habitual or subsequent to the plan to commit said felony, but when the intoxication is habitual or intentional, it shall be considered as an aggravating circumstance, no? There are other relatives included po by analogy, no? The relationship of stepfather or stepmother, mga stepson, stepdaughter, mga step-step, no? The reason, it is the duty of the step-parents to bestow upon their stepchildren a mother's or a father's affections, care, and protection. No, the relationship of adopted parent and adopted child. But, no, you have to take note, but the relationship of uncle and niece is not covered by any of the relationship mentioned. Okay, we are now here in the persons criminally liable for felonies. Okay, who are criminally liable? Meron tayong principal, merong accomplice, merong accessory. Sino-sino ba to, no? Okay, principal. Meron tayong tinatawag na those who take direct part in the execution of the act, those who directly force or induce others to commit it, those who cooperate in the commission of the offense by another act without which it would not have been accomplished. That is principal by direct operation. Kung hindi dahil sa kanya, hindi sana ma-accomplish yung pagtakas nila, something like that, no? Those are principal. So let's focus on the first principal by direct participation muna, no? They are those one who personally takes part in the execution of the act. They shoot, they kill, burn, hack, drown, or any something like this, no? Okay, example, a person who sets his enemy's house on fire, a gang member who shoots and kills another rival gang member, no? And again, no, two or more persons who took part in the commission of the crime are principal by direct participation. Again, this principal by direct participation, it is not just committed by one person, pwede din two or more person, katulad nito. Itong si A, si B, at si C, they were the rejected suitors of E because her heart already belonged to X. Yun na pala, yung heart niya, naka-X na, kaya ni-reject na itong tatlo. The three of them plan to kill X. So, yaon kini silang tulo, plano sila, patyo nila sa X. Anong siya may nakatag-iya sa heart, no, ni E. Okay? When A, B, and C saw X, A ran up to X and got him in a rear neck choke. But, naked choke, no? But, B got hold of a piece of metal and hit X's head. C pulled out his knife and stabbed X. Ang nangyari, patay buhay. Okay, perteng patayan ni X, no? So, they are all principal by direct participation. Okay, they participated, no, again, you have to take note, no, they participated in the criminal resolution. They are considered to have participated in the criminal resolution when they were in conspiracy at the time of the commission of the crime. No, conspiracy here is not a felony, but only a manner of incurring criminal liability. Conspiracy does not require necessarily an agreement, but the clear act that they acted in unison. That is enough. They carried out their plan and personally took part of its execution by acts which directly tended to the same end. Next, principle by inducement. By directly forcing another to commit a crime. Anong ginamit nila? Irresistible force or causing uncontrollable fear. No, the person who used force or caused fear, siya lang yung criminally liable. You have to take note that. Okay, another. By directly inducing another to commit a crime. There are two ways of directly inducing another, no? Giving prize or offering reward or promise like gun for hire. Okay, so that's it, no? Principle by inducement. Okay, in order for a person to be convicted as a principle by inducement, the inducement must or be made, no, with the intention of procuring the commission of the crime, and such inducement be the determining cause by the one executing the same. Okay, under Article 17 of the Revised Penal Code, a principle by inducement either directly forces or directly induces another to commit the crime. There are equally two ways of committing each mode, no? Directly forcing another to commit a crime may be accomplished by using irresistible force or causing uncontrollable fear, whereas directly inducing the commission of a crime may be by giving a prize, reward, or promise, or by using words of command. Yun yung tandaan nyo. Next, principle by indispensable cooperation. Okay, those who cooperate in the commission of the offense by another act nang hindi dahil sa kanya, hindi sana na-accomplish nila. Siya talaga yung pinaka malaking ambag. Okay, so merong scenario na ganito, no? And then, ano ba yung mga krimen nila? Principle as to these are the illustration, no? Principle by the indispensable cooperation. Okay, say for example, in principles by indispensable cooperation, A was the custodian of prisoners Z. So, itong si Z, he was a detention prisoner. Sa X naman, convicted prisoner. Again, sino yung custodian prisoner? Siya A. Si Z at saka si X, they convince A na custodian prisoner to allow them to escape pagdating ng alas 12 ng hating gabi. When midnight arrived, eto naman si M, the cousin of Z. Sino nga itong si Z? He was a detention prisoner, no? With whom he conspired. Picked the lock of the gate and fetched Z and X, and he drove them to a predetermined hideout. Ano bang mga pananagutan nila, no? What is the liability of A as a custodian? That is, ano ba yung naano niya? That is Article 223, no? Conniving with or consenting to evasion. No, ano ba to? Any public officer who shall consent to the escape, binigyan niya ng consent na maka-escape yung prisoner under sa kanyang kustodiya. Yan yung pwedeng kay A, no? Conniving with or consenting to evasion. How about kay X, yung convicted na to, ha? Hindi na tinapos yung sentensya niya, no? So, evasion of service of sentence, no? Impose upon any convict who shall evade service of his sentence by escaping during the term of his imprisonment by reason of final judgment. How about si M? Anong liability ni M? That is this Katzen. That is delivery of prisoners from jail. Kasi ni-remove niya, no? Any person who shall remove from any jail or penal establishment, any person confined therein or shall help the escape of such person by means of violence, intimidation, or bribery. Okay, itong si Z naman, ano liability ni Z? Yan na, ito na siya. Principal by indispensable cooperation in the crime of delivery of prisoner from jail. Kung hindi dahil sa kanya, hindi sana sila nakatakas, no? Okay. Next, Article 810. Accomplice. Sino ba itong mga accomplice na to? No, those person who not being included in Article 17. Hindi siya principal. Cooperate in the execution of the offense by previous or simultaneous act. So, anong ginawa niya? Hindi siya principal. Pero nag-agree siya. He agreed to the situation made by the conspirator but not included in conspirator's plan. Hindi siya kasali sa plano pero nag-agree siya. Okay, and then there is participation. They are the accomplice. Say for example, A hires B to be a lookout and a getaway driver, and then they commit the crime. So, nag-agree siya no na maging lookout siya. So, he is an accomplice. Si A is the principal and B is an accomplice kasi nag-agree siya. Hindi niya alam kung anong plano ni A. Why? Because B drove to the scene, stayed there to look out for the police, and then drove A away. Article 19, accessories. Sino ba itong matatawag nating accessories? Those who having knowledge of the commission of the crime. Alam nila, may alam sila, no? And without having participated therein, either as principals or accomplice, take part subsequent to its commission in any of the following manners. First, by profiting themselves or assisting the offender to profit by the effects of the crime. Ito naka-benefit sila. Or by concealing or destroying the body of the crime or the effects or instruments thereof in order to prevent its discovery. By harboring, concealing, or assisting in the escape of the principal of the crime, provided the accessory acts with abuse of his public functions or whenever the author of the crime is guilty of treason, parricide, murder, or an attempt to take the life of the chief executive, or is known to be habitually guilty of some other crime. Okay, complex crime. Okay, although there are actually 2 or more crimes, the law treat them as constituting only one, as there is only one criminal intent. So therefore, isang information lang yung i-filed. Okay, merong 2 klase ng complex crime. First, compound crime. Single act constitutes 2 or more grave or less grave felonies. Okay, requisites. That only one single act is performed by the offender, that the single act produces 2 or more grave felonies, 1 or more grave and 1 or more less grave felonies, 2 or more less grave felonies. Second, complex crime proper. When an offense is a necessary means for committing another. So, no, at least 2 offenses are committed. One or some of the offenses must be necessary to commit the other, or that both or all the offenses must be punished under the same statute. No single act in the following cases, ha? Okay, when 2 persons are killed one after the other by different acts. Although these two killings were the result of a single criminal impulse, the different acts must be considered as distinct crimes. When the acts are wholly different, not only in themselves, but also because they are directed against two different persons, as when one fires his gun twice in succession, killing one and injuring the other. Okay, you have to take note, light felonies produced by the same act should be treated and punished as separate offenses or may be absorbed by the grave felony. You have to take note, when in obedience to an order, several accused simultaneously shot many persons without evidence how many each killed. No? There is only a single offense. There being a single criminal impulse. For the attainment of a single purpose which constitutes an offense, various acts are executed. Such acts must be considered only as one offense. When a complex crime is charged and one offense is not proven, the accused can be convicted of the other. There is no complex crime of arson with homicide. It is not a complex crime when trespass to dwelling is a direct means to commit a grave offense. Like rape, no? There is no complex crime of trespass to dwelling with rape. Trespass will be considered as aggravating or that is unlawful entry or breaking part of a dwelling. Okay, there is no complex crime in the following: in case of continuing crimes, when one offense is committed to conceal the other, when the other crime is an indispensable part or an element of the other offenses are defined, or as defined, where one of the offenses is penalized by special law, when the law provides one single penalty for special complex crime, like robbery with homicide, robbery with rape, rape with homicide, kidnapping with serious physical injuries, kidnapping with homicide. Plurality of crimes, no? It is consist in the successive execution by the same individual of different criminal acts upon any of which no conviction has yet been declared. There are two kinds of plurality of crimes: formal or ideal. Okay, first, no, there is only one criminal liability in here. Formal or ideal crimes are further divided into three groups, where a person committing multiple crimes is punished with only one penalty. A. When the offender commits any of the complex crimes as defined in the article. When the offender commits any of the complex crimes. When the law specifically fixes a single penalty for two or more offenses committed, like robbery with homicide, kidnapping with serious physical injuries, and when the offender commits continued crimes. Real or material. There are different crimes in law as well as in the conscience of the offender. In such cases, the offender shall be punished for each and every offense that he has committed. Continued crime. It refers to a single crime consisting of a series of acts, but all arising from one criminal resolution. Although there is a series of acts, but there is only one crime committed, so only one penalty shall be imposed. Like kidnapping. Okay, example of continued crimes. A collector of a commercial firm misappropriates for his personal use several amounts collected by him from different person. Kahit na different person yan, pero same lang ng collection lang. There is only one crime because the different and successive appropriation are but the different moments during which one criminal resolution arises. Another, Juan steals 2 books belonging to two different persons. He commits only one crime because there is unity of thought in the criminal purpose of the offender. Okay? A continued crime is not a complex crime, as the offender does not perform a single act but a series of acts. Therefore, penalty not to be imposed in the maximum. No actual provision punishing continued crime. It is a principle applied in connection with 2 or more crimes committed with a single intention. A continued crime is different from transitory crime, no? Transitory crime is moving crime. Okay, distinction between degree and period. Ano bang kaibahan nitong dalawa na to, no? The degree, it refers to the penalty imposable for a felony committed considering the stages of execution and the degree of participation of the offender. As to the period, it refers to the duration of the penalty consisting of the maximum, medium, and minimum after considering the presence or absence of aggravating circumstances. So the degree, it may refer to both divisible and indivisible penalties. Well, the period, it refers only to divisible penalties. Okay. Article 62 of the Revised Penal Code, effect of the attendance of mitigating or aggravating circumstances and of habitual delinquency. Aggravating circumstances have the effect of increasing the penalty without, however, exceeding the maximum period provided by law, while the mitigating circumstances have the effect of diminishing the penalty. Habitual delinquency, it has the effect not only of increasing the penalty because of recidivism, which is generally implied in habitual delinquency, but also imposing an additional penalty. Again, what is the difference between habitual delinquency and recidivism? In habitual delinquency, crimes to be committed are specified, while the recidivism is same title. The habitual delinquency, that is within 10 years. In recidivism, there is no time that is fixed by law. In habitual delinquency, it must be found guilty 3rd time or oftener. In recidivism, in the 2nd conviction. In habitual delinquency, additional penalty is imposed, while in recidivism, that is not offset. Article 89 of the Revised Penal Code. How the criminal liability is totally extinguished. Kailan ito maaalis? Kailan ito totally mawala? Itong criminal liability, no? Paragraph 1 is by death. Pag namatay ka na. Extinguishment of the criminal liability is a ground for motion to quash. Okay, kunyari tinanong kayo ha, the death, the criminal liability, whether before or after final judgment, is extinguished upon death. Hindi ito terminate ha, hindi dismissed, but extinguished upon death because it is a personal penalty. Pecuniary penalty is extinguished only when death occurs before final judgment. The death of the offended party, however, does not extinguish criminal liability of the accused because it is a crime against the state. Paragraph 2, by service of sentence. You have to take note, pagkatapos mo ng servisyoan yan sa loob ng bilangguan, yun na, pwede nang ma-extinguish yung criminal liability mo. Kasi yung crime, utang yan na kailangan mong bayaran. Ma-extinguish lang yan pag bayad ka na. Ano bang maging kabayaran? Servisyohan mo talaga sa loob. Service does not extinguish civil liability. Another extinguishment of criminal liability by amnesty. Amnesty, that is an act of the sovereign power granting oblivion or general pardon. It wipes all traces and vestige of the crime but does not extinguish civil liability. Okay. Another, paragraph 4 by absolute pardon. Pardon, that is an act of grace proceeding from the power entrusted with the execution of laws, which exempt the individual from the punishment the law inflicts for the crime. Paragraph 5 by prescription of crime. What is prescription of crime? That is the loss or the forfeiture of the right of the state to prosecute the offender after the lapse of a certain time. You have to take note that when the crime prescribes, the state loses the right to prosecute. So, prescriptive periods of crimes. Crimes punishable by death, reclusion perpetua, or reclusion temporal, no? Those are 20 years. Afflictive penalties, that is 15 years. Correctional penalties, 10. Except those punishable by arresto mayor, which will prescribe in 5 years. Crime of libel, that is 1 year, Offenses of oral defamation and slander by deed, 6 months. And the light offenses, that is 2 months. Paragraph 6, by prescription of penalty. It means the loss or forfeiture of the right of the government to execute the final sentence after the lapse of a certain time. The condition here is that there must be final judgment and the period must have elapsed. Article 103, subsidiary civil liability of other persons. What is the difference between civil liabilities and pecuniary liabilities? First, it includes reparation and indemnification. Same lang sila, no? And then, it includes restitution. Nothing to pay in terms of money. In pecuniary, no restitution as the liabilities are to paid out of the property of the offender. In the civil liabilities, no fines and cost of proceedings. In pecuniary, it includes fines and cost of proceeding. Okay, what is included in civil liability? The first remedy granted by law, that is the restitution. Ano ba itong restitution? The thing taken away by the offender. Okay, isoli mo yung kung ano yung ninakaw mo, kinuha mo, isoli mo yon. If restitution cannot be made by the offender or by his heirs, the law allows the offended party reparation. Okay, pwede mong bayaran na lang, In either case, indemnity for consequential damages may be required if that is the loss of salary or wages. Again, yung restitution na, kunyari in theft, the culprit is duty bound to return the property stolen. Okay, reparation, in case of inability to return the property stolen, the culprit must pay the value of the property stolen. In case of physical injuries, the reparation of the damage caused would consist in the payment of hospital bills and doctor fees to the offended party. And that indemnification of damages, that is the loss of salary or earnings. Alright, so much for that. Thank you for listening, everyone. And